Well, hello, everybody. I'd like to welcome you to today's event, Reflections on the Legacy of Justice John Paul Stevens. I'm Caroline Fredrickson. I'm the Executive Director of the American Constitution Society for Law and Policy. For those of you who may be unfamiliar with ACS, we are a national network of lawyers, law students, scholars, policymakers, and judges that promotes the vitality of the U.S. Constitution and the fundamental values it expresses: individual rights and liberties, genuine equality, access to justice, democracy, and rule of law. Before we get started with today's program, I would like to give a special thanks to Skadden for hosting us, and particularly to Cliff Sloan, who's not only on the panel today, but is a board member of ACS and is a partner here at Skadden. So thank you so much, Cliff and Skadden, for this beautiful room. And thanks all of you for coming, and I'm very, very happy to see many of what I presume are summer associates, and that's just because you're younger than me, so I assume you must be summer associates, because I'm just barely out of law school myself. And Professor Liebman won't contradict me. No, I was in his class quite a number of years ago. So anyway, we have a really extraordinary program for you today, so I'm not going to spend very much time talking. I'm very, very pleased to have Adam Liptak here with us to moderate today's event. Adam is the Supreme Court correspondent for the New York Times. And we have 6 amazing panelists who all served as clerks for Justice Stevens. And as you all know, after 34 years on the bench, Justice Stevens announced his decision to retire from the Supreme Court at the end of this term. Justice Stevens, who recently turned 90, is the longest-serving member of the current Supreme Court by more than a decade, giving him a historical perspective unlike any other sitting justice. Today, our panelists will discuss Justice Stevens' unique role on the court, his contributions to the development of particular areas of law, the impact of his departure on the court, and they will share their personal reflections on experiences as clerks in his chambers. And it's my particular pleasure to introduce our moderator, Adam Liptak. And you all have very complete biographies in the handouts you received, so I'm not going to go into a great deal of detail, because that would use up all of today's time delineating what Adam's accomplishments are. But suffice it to say that Adam is the most perfect person we could have to moderate today's discussion. In addition to covering the Supreme Court for the New York Times, his biweekly sidebar column explains the significance of legal developments, what's really going on in specific cases, and describes the intersecting orbits of lawyers, clients, lawmakers, scholars, and judges. Adam first joined the New York Times as a copy boy after graduation from Yale, where he was the editor of the Yale Daily News magazine. And he rejoined the Times legal department after attending Yale Law School and working at Cahill Gordon, focusing on First Amendment. In 1995, Press Time magazine named him one of the 20 leading newspaper professionals under 40. In 1999, he received the New York Press Club's John Peter Zenger Award for defending and advancing the cause of a free press, and he was a finalist for the Pulitzer Prize in Explanatory Reporting in 2009. Please join me in welcoming Adam Liptak.
Thank you very much, Caroline. Those of you who attend the occasional Supreme Court argument know that there's a crucial moment in every one. It comes near the end of the half hour for any given advocate, and you hear all of a sudden a courtly voice from the Chief Justice's right asking with a kind of courtesy that is unique on the modern court, "Counsel, may I ask you a question?" That voice belongs, of course, to Justice Stevens, and the correct answer to that question, by the way, is yes, you may ask me a question. And the question that follows, then, is almost always a missile aimed at the heart of the case and at the brain of Justice Kennedy. And we will truly not see his like again. It's a court in which a lot of big personalities bounce around and say the goofiest things. But if you want a trenchant question that cuts to the heart of the matter, you'll look to Justice Stevens. Not long before he announced his retirement in April, he was gracious enough to agree to an interview with me. And he reflected on what may surprise some of you, on his earnestly held view that he's a conservative justice. Let me read just a couple of lines from that interview to give you a sense of the justice's thinking. He said, "There's a great deal of wisdom to the notion that you try to decide cases narrowly, and you let the other decision makers make as many decisions as they can. What really, for me, marks a conservative judge is one who doesn't decide more than he has to in order to do his own job." Perhaps Justice Stevens was thinking about Citizens United. He went on, "Our job is to decide cases and to resolve controversies. It is not to write broad rules that answer society's questions at large." We're very lucky today to have with us 6 of Justice Stevens' former clerks to help us understand this legacy. I'm going to introduce them briefly. As Caroline said, there are bios distributed somewhere. And then I'm going to ask them to do the impossible. I want them to say a little bit about the justice's engagement with a particular area of the law, and to give us a sense of the justice as a person, and something about his work habits and his interactions with his colleagues, and then the arc of his career. And we'll do this in 5 minutes each. So obviously, we'll just get a taste from each of our panelists, but we'll follow that with a discussion that will try to draw out some themes across really generations here, and then we'll make time for your questions. As is the custom at the court's private conference, we'll hear from the panelists in order of seniority. Jim Liebman, to my left, served in the 1978 term. He's a law professor at Columbia and a trailblazing giant in scholarship on the death penalty. After that, Cliff Sloan from the 1985 term, our host here, a partner at Skadden, was a former executive at the Washington Post Company and is the co-author of a really smart and engaging book on Marbury v. Madison called The Great Decision. Melissa Hart, next, is a law professor at Colorado University and a 1996 clerk. She's an authority on employment discrimination and has lately focused some of her attention on a class action against Walmart that seems to me almost certainly headed for the Supreme Court. Deborah Pearlstein, a 1999 clerk, is visiting at Georgetown Law and based at Woodrow Wilson at school at Princeton. Deborah did pioneering work at Human Rights First on the last administration's detention and interrogation policies. Amanda Leiter, a 2003 clerk, teaches at Columbia and has focused much of her scholarship on administrative and environmental issues. She was appointed by the court to argue an immigration case this term, a task the court does not assign lightly. You can see her name now in a decision handed down in January with Justice Ginsburg writing that Amanda had ably discharged her assigned responsibilities. Finally, Jamal Green, also from Columbia Law, served in the 2006 term. He has the only credential that could possibly compete with the resume glitter that you've just heard. Jamal used to be a reporter for Sports Illustrated. With that, I'll ask Jim Liebman to say a few words.
Well, thank you for having me, even if I do get to be the oldest one left standing here. You could sort of maybe describe the brief remarks I'm going to make, mostly about some of Justice Stevens' opinions and ideas, as something new and something borrowed, and then something old and something blue. So let me start with the new and borrowed, really new and shared. And by this I mean a kind of jurisprudential innovation that Justice Stevens and Justice Stewart created to interpret the Eighth Amendment. As all of you know from your law school experience, the Eighth Amendment is the starkest counter-majoritarian dilemma. It tells judges that they have to rule on the constitutionality of punishments, but it gives them only those 4 incredibly ambiguous words to go on in figuring out what to do and how to do that, and those words leave open the possibility that judges will be tempted to decide based on their own values and not something that qualifies as law. Well, in a dozen cases going back to the mid-1970s, really to the beginning of Justice Stevens' term, and culminating just 2 weeks ago in the Graham versus Florida juvenile case, the court sort of came up with a solution. And Justice Stevens is the only justice who was in the majority in all of those cases that remain good law as of this point. And one of those opinions in 2002, Atkins against Virginia, invalidating the death penalty for mentally retarded offenders is, in my view, the best of all of those cases. And the better solution the court came up with was for the court to essentially inform its own judgments by amassing literally thousands of decisions of coordinate democratic institutions made nationally over decades in order to reveal a kind of national consensus as to the appropriate punishment for particular crimes or offenders. Using this approach, the court takes kind of a head count of what all the legislatures are doing. It also reviews what actual sentencers do when they have discretion to impose or not impose a particular punishment, and also looks, God forbid, at what other countries are doing. And based on that, the court then reaches its own conclusion, but in fact, it has always, in doing so, reached the conclusion that's consistent with this modern consensus that has been revealed. Well, Justice Stevens and Stewart took this innovation a step further. They wanted to, in these cases, the mass of the death penalty cases, addressing the constitutionality of the death penalty for murder. And in the first of these cases, where Justices Stevens and Stewart actually co-wrote the decision along with Justice Powell, they concluded that the death penalty is not always unconstitutional or always constitutional for murder. So then they had to decide when is it and when isn't it. And what I think they tried to do was to essentially read the Eighth Amendment to require procedures through which they would force legislatures and many, many juries to essentially publicly reveal a national moral consensus on which murders were appropriate for the death penalty and which weren't. And the way it was supposed to work was legislatures were going to adopt and juries were going to apply aggravating circumstances to find those very small number of core cases for which the death penalty was appropriate. They test whether it truly was a core case by looking at mitigating factors and doing some balancing. Then the appellate courts in the state would actually look at all of the capital cases in that state and non-capital cases for murder, try to figure out where that state's core was and throw out the outliers. And then the Supreme Court would do backup review, which would include, in essence, comparing all of the state's cores to each other and throwing out outlier cores. And the court actually did this for about a decade in the 70s and into the 80s. But after a while, the Supreme Court decided it didn't want to do its part of the work, and it refrained from doing any more real review of the procedures and the patterns that were resulting. And obviously one of the most unfortunate examples of this was the McCleskey case, in which the Supreme Court essentially said, we're going to allow Georgia to continue using procedures that were generating death sentencing patterns that were explainable on no basis other than the race of the victim. Justice Powell said that was necessary to save the entire criminal justice system, fraught as it is with racial disparities, but Justice Stevens pointed out that actually it was a very simple thing. The studies on which these disparities were based showed that at very high levels of aggravation, if you really did get it down to the worst of the worst cases, the discrimination and disparities went away, so that was all they needed to do to order Georgia to get more narrowed in its aggravation. But after a couple decades of the court essentially shirking its responsibilities, in the Bays decision in 2008, Justice Stevens had pretty much had enough. And so he pointed out that the Supreme Court in Gregg had essentially seen this as an experiment. Could the states figure out, after looking at what other states were doing, trying to generate this national consensus, could they figure out what the worst of the worst was? And Justice Stevens there catalogs about 2 decades of the Supreme Court's failure to police that experiment, to review the procedures and patterns, and essentially concluded then that the jumble of flawed sentences that were resulting across the country left the death penalty as, quote, the pointless and needless extinction of life. But what I want to say here is that Justice Stevens really provided the court with a model for a new way to interpret the very difficult parts of the Constitution by essentially using constitutionally mandated procedures to force democratic values to reveal themselves so the court could then rely on those democratic values to back up the difficult judgments that the Constitution requires it to make. And though the experiment in the death penalty didn't work, I think this is a valid and important jurisprudential tack strategy that I hope the court will use in the future. What then is Justice Stevens' old and blue legacy? Well, it too is reflected in Bayes. Interestingly, Justice Stevens announced that he was no longer willing to see the death penalty as constitutional in a case in which he concurred in the outcome of the court, which was to allow an execution to go forward using lethal injection. Most of the justices, all of the other justices who have decided they're against the death penalty constitutionally, have no longer been willing to vote for the death penalty in any case. But Justice Stevens said, "The conclusion I have reached with regard to the constitutionality of the death penalty makes my decision in this case particularly difficult, but it does not justify a refusal to respect precedents." And I think that really is the other legacy that I want to refer to. This respect for the integrity of the law, even over a solemn view about the cruelty of state-sanctioned killing. I myself am deeply against the death penalty, but I have to say, after thinking about it, on balance, I think the justice was right, and that the law and its integrity should come first. And as Adam has written, I think Justice Stevens is the last of a breed of great American lawyers and judges who really did put the integrity of the law above all else, saw the integrity of the law as something that was real and living. And I think that although it's a little old-fashioned to say, we all ought to be a little bit blue, a little bit sad that the passing of that generation is upon us.
Thank you very much, Jim. Cliff?
Thanks, Adam. I want to make a few points about Justice Stevens. And the first is a personal point. And you've got a panel here of 6 people who clerked for Justice Stevens. We had a reunion about a week or two ago of all the Stevens clerks. I think it's 119 clerks, including the clerks on the 7th Circuit, spanning 40 years from the time he went on the 7th Circuit until now. And the amazing thing is that if you talk to any Stevens clerk, any of those 119, they will tell you exactly the same thing about what a remarkable experience it is to clerk for him, not just in terms of his brilliance, not just in terms of his fidelity to the law, as Jim has been talking about, but just as a kind, decent, generous, fun person. It's an amazing experience. And I thought that Justice Souter expressed it really well in his statement upon the retirement of Justice Stevens. He first praised Justice Stevens and his record as a justice, and he said, "Besides, he's a friend of mine, which makes me as lucky as anyone can get." And all of us up here are former clerks to Justice Stevens, which makes us as lucky as anyone can get. And we can talk more about that in the course of the discussion, if you like, in terms of kind of personal anecdotes. Second point I wanted to make, I made the argument this week on SCOTUS blog that Justice Stevens is the greatest justice in the history of the Supreme Court. I leave out of that the Chief Justices because they have powers that are unavailable to the Associate Justices. And briefly, I'll tell you the 4 reasons why I think that Justice Stevens is the greatest justice in the history of the Supreme Court. And I will point out that sometimes while history is being lived and while greatness is in front of you, it's hard to kind of step back and realize the full force of it. But let me put out there for your consideration and for discussion 4 reasons, 4 historic accomplishments of Justice Stevens. The first is his leadership in enforcing the rule of law in a time of war. The trilogy of decisions about Guantanamo, 2 of which he wrote, the 3rd of which he was a key member of the majority. That's a historic accomplishment. At other times in our history, when there have been claims of war and unfettered authority, the Supreme Court has flinched. It did not flinch this time, and that's because of Justice Stevens. And that is a very historic accomplishment for him, for the court, and for the rule of law. Second is on questions of personal freedom and personal liberty. As Jamal has written in a number of places, Justice Stevens really has recalibrated, refashioned the court's framework for addressing questions of personal freedom, whether it's sexual orientation, whether it's choice, a host of other areas. And he has shifted the jurisprudence from a privacy framework to a liberty framework. And as a result, it's much more firmly grounded, in my opinion. And one particular example of that has to do with sexual orientation. And the term that I clerked, I worked with him on his dissent in Bowers versus Hardwick, in which he dissented from the court's conclusion that a criminal ban on sodomy was permissible. 17 years later, Justice Kennedy, writing for the court, said Justice Stevens was right in Bowers. His opinion should have controlled, and it controls now. And that dissent talks about the abiding interest in liberty. And it goes back to a case where he set that out on the Seventh Circuit. I think that's a historic accomplishment on the framework of personal liberty. Third, he's even-handedly applied the rule of law to presidents of both parties. Everybody remembers his famous stirring dissent in Bush versus Gore, where he excoriated the court for trampling on the orderly process of the Florida state courts. A few years earlier, in Clinton versus Jones, in the Paula Jones case, I think he expressed exactly the same respect for the rule of law against a president's claim when President Clinton was saying that the litigation against a president should be deferred until after his time of office. And he was respecting the orderly process of the federal courts in the same way. And the fourth is that in a wide variety of areas, whether you're talking about environmental law, the First Amendment, and cyberspace, a whole host of other areas, the scope of congressional power, copyright law, on and on. The leading opinion, and an opinion that will shape the law for generations, is one of Justice Stevens. And we can talk further about that. But in a very wide variety of areas, he has written the seminal opinion that will shape the court for decades to come. Finally, one last point I just wanted to mention. Of course, we see Justice Stevens' influence and legacy in his opinions, and as I've just been talking about. But one thing I think that we uniquely know about and that people come to see when the papers of the justices come to life is the role that he plays within the court and the influence and the effect of his insights that then completely change the way the court is looking at a case. And as a witness on this, I'm going to invoke Justice Scalia and his statement when Justice Stevens stepped down. Of course, Justice Stevens and Justice Scalia tangle with each other all the time, including a few days ago in the Foreign Sovereign Immunities case about legislative history, and Justice Scalia isn't one to throw around compliments lightly. And in his statement, he said this, which I thought was very interesting. He said, in addition to other things, he said, in many, many cases where he did not write, he brought to conference brilliant and distinctive insights that affected the outcome. And I would bet you that each one of us on the panel could give you an example of a case from our term where Justice Stevens saw the case in a very different way from the way that both sides were arguing it, and it profoundly affected the way the court then decided the case.
That's very good. So we're a third of the way in, and we've already established that Justice Stevens is the greatest justice ever. Melissa, can you top that?
Yes. I haven't figured out how yet, but I have 5 minutes, right? Thank you very much for giving me the opportunity to be on this panel and to have a chance to talk about Justice Stevens. I clerked with Justice Stevens during the 96 term. We had a lot of big cases. That was the year of Clinton against Jones, the Prince case that found the Brady Act to be unconstitutional, Communications Decency Act case. It was a really interesting term to clerk. But actually, the cases that I remember most working with the justice on were not those cases. They were cases that get almost no attention, usually cases of statutory interpretation. We had 2 Jones Act cases, which blew my mind because it's been around since 1938 and there were still questions. I sort of couldn't believe it. But they were questions, and they were real questions that really affected the lives of people whose work is covered by the Jones Act. Questions about ERISA. I mean, really, when the clerks were dividing up cases and who got to work with the justice on cases, these were the absolute dregs of the cases. And yet he always helped me, and I think helped my co-clerks understand why, for the people whose lives were affected by these cases, they were incredibly important, and why they mattered, and that work mattered at least as much as the big deal work that the court does. And he always took incredible care on those cases, and both in writing the opinions when he was writing the opinions, and in talking about with all of us why they mattered, and thinking about what was happening in these cases, why these questions did keep coming up. He was interested in not just what's the legal question here, but why does it happen that we still have so many open questions about the Jones Act? What's going on in that social dynamic? I think that's one of the things that for me made him so significant, and I guess I was very struck last year when the public, or at least the legally obsessed public, sort of debated about the merit or lack of merit of empathy as a quality in a justice, and somehow it got portrayed as a negative that everyone was trying to back away from. And that strikes me as crazy for lots of reasons, but one of the reasons it strikes me as crazy is because I would say one of Justice Stevens' most clear qualities is that he is a deeply empathetic person, and that has always been an attribute of his judging, of his teaching, and it's the other area where, for me, when I was clerking, it was very notable. And I'm not an expert in the death penalty at all in terms of the law, but I had to, as all clerks have to, spend a lot of time on the death penalty when I was clerking, and in the term that I clerked with him, he still took the view that he didn't particularly care for the death penalty, but it seemed to him that it was constitutional. But during that year, and this was again 1996, so it was 12 years before he decided it probably wasn't constitutional, we had a number of cases come up that presented really disturbing facts in terms of who was being executed, disturbing facts in terms of how the execution occurred. And he clearly was worrying about it a lot and thinking about it and talking about it. And while the opinions he wrote and the opinions he joined were opinions that followed the law, it was never far from his mind and far from the conversation that, again, these are real people whose lives are being ended by this experience. And the one moment that I actually don't usually share much about the year of clerking. I take the view that we're not supposed to, but I feel like this story just summed up for me so completely who Justice Stevens is as a person and as a judge. One case that I stayed up late working on, there was a request for a stay of execution. It was a Florida case. Ultimately, the court decided not to grant a stay, and Florida tried to execute, and I guess ultimately did execute the man, but it was his head caught on fire. It was the electric chair, and there were stories in the newspaper the next day about how grim the whole thing was. It was a Friday night, and I frankly completely devastated and somewhat hysterical. And at about 9 Saturday morning, I'm at home, and my phone rings, and it's Justice Stevens, and he said, I saw the paper, and I just knew that you would be feeling as bad about this as I am. And I just thought, like, that's, A, he felt bad, B, he knew that I would, and C, he called. And I just, like, that was one of the most amazing moments of connection. Again, did that affect the outcome of the case? No, not that case, but I think it affects that kind of empathy in every direction, affects the kind of justice that he was. And I hope that it's recognized in the future as a great quality, not a quality to run from. I want to say, and I'm scared that I'm running past my time, but how I think that this empathy and connection with the facts of the case, with what's happening in the cases, has also affected the area that I write in and study most is employment discrimination and discrimination more generally. And there are lots of ways in which the justices focus on the facts and focus on sort of how the facts affect the law and how legal development affects the facts, both together, has affected his writings in this area. One area in which he's quite different from lots of the other justices has been in his willingness to accord some deference to the EEOC, to recognize that there is an expertise in the subject of discrimination that we don't all necessarily have. You can understand a lot about how discrimination happens from studying it. And that's something, and I know others on the panel are going to talk about deference to agencies, but the EEOC is an agency that has not gotten its due deference most of the time. And Justice Stevens has been more concerned about that than others. And I think that's, again, because he recognizes that these facts are hard facts to understand, not as I think many on the court think, something we can all recognize and that everyone's view of discrimination takes account of all the many factors. And I think similarly in the area of affirmative action, which is an area that definitely people look at the justice's views and say he changed over time. It's sort of hard not to say he changed over time because he kind of did. But I would argue, as many have in the areas where he changed, that the change was, there was a piece of what he was doing that changed, but a piece that really never did change. And again, that's his recognition that the facts matter and that what you're doing is you're looking at, when you're applying law, it's not in the abstract, it's to the world and to the facts in front of you. And I think in the 1970s, when Justice Stevens was involved in the Bakke decision and looked at the University of California's medical school application process, at that time he still believed that a neutral process could end the persistent problem of discrimination. And by the time he had served on the court for long enough and lived in this world for long enough and seen that discrimination had a persistence that defies all of his hopes and all of many people's hopes, and that was not being addressed by race-neutral policies, that at that point he recognized that in order to achieve true equality, in order to have the reality of what the principles behind the equal protection and behind notions of non-discrimination mean, different practical policies would have to be applied, so that by the time you get to parents involved in community schools, for example, at that point he could say, look, we have to stop pretending that ignoring race is a way to solve the persistent problem of race discrimination. And I think rather than seeing that as a change in his belief system, I think it's also important to recognize it as his willingness to look at the facts and to say, what I had hoped is not true, and we have to acknowledge it when it's there. Thank you.
Thank you. Thank you so much. Deborah?
Thank you, and thanks to ACS and to Cliff and Scott in particular for hosting this. I already learned so much from my fellow co-clerks. Since the Justice announced his intention to retire a couple of weeks back, a lot of the questions or a lot of the sort of characterizations of what the significance of this is and the loss of Justice Stevens in particular has referred to his military service. This is the last veteran of World War II. This is the last person with any significant military experience on the court to leave the court. And indeed, the Justice has joked on more than one occasion that, he enlisted in the military the day before the Japanese bombed Pearl Harbor. And it became clear, as the Justice had said, immediately that the enemy was going to respond to his decision to enlist. Which, may be some indication of a sense of humor, although there are many others I could give. And as it turns out, and as this was already mentioned, he had occasion during his tenure on the court to decide the most significant cases in national security law in a generation or more. Obviously, Rasul, the Guantanamo case, Hamdan, the case invalidating the military commissions as beyond the president's authority to do without congressional authorization, probably stand out above the others. To me, and this also relates to the point you were making about his attention to facts and his respect for the idea of expertise, I think that these particular cases these cases reflect a very particular kind of wisdom, a wisdom that I'll argue was drawn both from, at some level, his military service, but also from a lifetime of attention to the persuasiveness or not of the reasoning of the executive branch. So let me first just give a little bit of history, and then I'll talk about sort of the expertise and deference sort of questions. So, as many of you I'm sure know, right after World War II, Justice Stevens, then John Stevens, clerked himself at the Supreme Court for a little-known justice named Wiley Rutledge. Rutledge had himself struggled with, in that era, the most significant security cases of the time that raised a lot of the same questions of executive power and individual rights and national security that the court has faced since 9/11. And in these cases, Rutledge had initially felt compelled to defer to, at the time, a very powerful President Roosevelt, in cases, for example, which the court upheld the military curfew in certain areas against Japanese Americans living in California, a case called Hirabayashi, and then, of course, famously to uphold the exclusion of these citizens from certain zones in California in the case called Korematsu. And Rutledge was, in both of these decisions, in the majority, voting to uphold the executive's authority. But it seems clear from Rutledge's biographer that he pretty quickly came to regret these decisions, so that by the time In re Yamashita came to the court, which was one of the last major military commission's cases to come to the Supreme Court before Hamdan itself, this involving the military commission trial by the U.S. military of a Japanese general right after World War II. And in Yamashita, the decision issued the year before Stevens comes to the court as a clerk, Rutledge writes really one of the most eloquent and powerful dissents on the court in any sort of area that I've read, in which he says, acknowledges, look, exigencies can arise, but particularly where the government response to emergencies, war, et cetera, imposes a burden on individual rights, it was within the power of the courts to check the reasons for the response in security matters as anywhere else. Now, I'm paraphrasing, but the essence of his dissent, one of the critical pieces of his dissent, was the notion that, or a reflection of the notion that it's the court's responsibility to ask questions. Is it absolutely necessary to deprive this person of really a panoply of procedures that we otherwise view as absolutely necessary in any sort of criminal prosecution? Okay, so fast forward 60 years, and now Justice Stevens is sitting on the court facing Hamdan, the next major military commission case certainly of his era, in which the Supreme Court's asked to evaluate the legality of military commissions at Guantanamo Bay. And Stevens writes for the majority, holding that the president lacks authority to establish military commissions without congressional authorization. One of the many remarkable things about the Hamdan decision is that the opinion of the court, written by Stevens, shows absolutely no deference at all to the executive. Critically, on questions of statutory interpretation, what does the Uniform Code of Military Justice mean about you have to make military commission and courts-martial procedures uniform insofar as practicable, nor does it show any deference to the president on the meaning of the Geneva Convention treaty interpretation, both areas in which many have argued, and I think black letter sort of con law treatises would say the president gets enormous deference, particularly in this context. And not only does the court not mention it, it dismisses very clearly the executive's paucity of reasoning for why it is it thinks military commissions are necessary. So on the one hand, in light of what I just told you about Rutledge and his sort of realization on the court during his tenure, this coming from Justice Stevens is perhaps not so surprising. It may be just a function of having learned the lessons in real time that Rutledge learned 60 years before and applying them in Justice Stevens' own tenure. But on the other hand, and we're about to hear in more detail, Justice Stevens is also famously the justice that wrote Chevron. In the standard administrative law context, the decision cited probably more often than any others, most commonly for the proposition of the importance of judicial deference to executive branch interpretations of statutes on the grounds, in part, of the executive's superior expertise. So how do you square Chevron, for example, on the one hand, and EEOC cases, with Stevens' behavior in Hamdan on the question of deference to the executive? My own view, I guess, is that these cases are actually more consistent, Chevron and Hamdan, that is, than they would at first appear on the question of how valuable executive views and executive expertise is or not. By the time Chevron came down, the court had long recognized, and as Stevens wrote in Chevron, that executive views could help illuminate statutory meaning when the executive has special expertise on a topic, when it is clear that the agencies, the executive agencies, usually consideration of the matter had been detailed and reasoned. But it was exactly the lack of such detail and reason in the president's justification for pursuing military commissions at Guantanamo that so troubled Stevens in Hamdan. He wrote in Hamdan, "Nothing in the record before us demonstrates that it would be impracticable to apply court-martial rules in this case. The only reason offered in support of that determination is the danger posed by international terrorism. Without for one moment underestimating that danger, it is not evident to us why it should require, in the case of Hamdan's trial, any variance from the rules that govern courts martial." And indeed, as amicus briefs and other writings in that case had made clear, the executive had largely excluded from the design of the military commissions before the court in 2006 the experts in the military, the JAG lawyers, the military lawyers who, of anyone in the U.S. government, have the greatest expertise in how to conduct a war crimes trial. So I would completely embrace and heartily agree with the conclusion that Stevens viewed expertise and record evidence as incredibly valuable, far more valuable than the mere assertion of executive authority, even on questions of national security. And for me, this is my field, whatever, I would put that at the top of the greatness of his legacy.
Thank you. Amanda?
I also wanted to offer my thoughts in two areas, first personal and then my area, which is environmental law. On the personal side, I haven't seen much writing about Stevens' view of women in the workplace, so I thought it was worth noting that I had a 6-month-old baby boy at home when I started.
Oh, thank you. Sorry. When I started clerking for him in 2003, and then last summer, I was home with my then 3-month-old baby daughter when Stevens called to ask, as Adam mentioned, whether I would be interested in being appointed to brief and argue this case before the Supreme Court. That is the second question we've heard about today, to which the only answer is yes. Yes, please. And so I, went to work right away, leaving my baby daughter at home at that point with my in-laws. And what I wanted to say about Stevens is that on both occasions, during the clerkship and last summer, Stevens neither ignored my parenting responsibilities nor sort of let me hide behind them. So, for example, in the clerkship, there were certainly occasions when child care emergencies called me away from my desk, and he sort of kindly looked the other way and let that go. But he didn't suggest in any way that I should or that he would relax his substantive expectations of me. And sort of that combination of, on the one hand, recognizing that, of course, this was a difficult juggling act, but on the other hand, fully expecting me to get my work done on time and well, gave me the courage to do my best work for him. And I will always be grateful to him that on those two occasions he had that confidence in me right at and sort of gave me a jump start back into the workplace on both occasions. On a professional level, I wanted to share my thoughts, as I said, on his environmental jurisprudence. No one, I think, would characterize him as a tree hugger. He has not spent his term on the court crusading for endangered species protections or clean air and water. As his friend Ken Manister has noted, there's some irony in that fact because he replaced Justice Douglas on the court, and Justice Douglas was known as nature's justice. Justice Douglas ardently advocated for a much more proactive role for courts in the environmental arena, and he, I think, would have supported creation of really a federal common law of the environment, substantive environmental law created by courts. By contrast, as we've heard, Justice Stevens really believes in a limited role for the courts in these complicated and technical areas and strong deference to expert agencies. Nevertheless, my view is that Justice Stevens has had
important and beneficial effect on the environmental movement, and I want to briefly explain why. To tell you that, or to explain that, I want to detail a little more about Chevron, which is the case that Deborah already mentioned, in which Justice Stevens announced his view that courts should defer to expert agencies. As we heard from Deborah, this is one of the court's most often cited administrative law cases, perhaps the most often cited case. The court announced its now familiar two-step analysis for the legality of agency action. Many people forget that this was, at bottom, an environmental law case. The court was evaluating the legality of an environmental protection agency rule that established the circumstances under which a power plant that wanted to undertake modifications that would increase its emissions had to first obtain a federal permit. And the Natural Resources Defense Council, for which I have to disclose that I worked for a few years, but not when Chevron was decided, had sued, arguing that this rule was insufficiently protective of clean air and violated the Clean Air Act. The court disagreed and upheld the rule, but they did so not because the justices thought that the rule made economic or scientific sense, but instead because first, and this is step one of Chevron, the court said that the Clean Air Act didn't have anything to say about EPA's substantive approach. And second, step two, when the act in question is silent on a point, the court said, courts should defer to the reasonable choices of the expert agency. This two-step analysis, as we've heard, came to be known as this Chevron two-step. Step one, look at the statute in question. If it speaks clearly to the question, that is the end of the matter. Step two, if the statute is silent or ambiguous, then defer to the agency's policy choice as long as it is reasonable. Justice Stevens explained the theory underlying this analysis as follows, and this is a quote from the opinion. When a challenge to an agency construction of a statutory provision really centers on the wisdom of the agency's policy, rather than whether the policy is a reasonable choice within a statutory gap left open by Congress, the challenge must fail. In such a case, federal judges who have no constituency have a duty to respect legitimate policy choices made by those who do. I don't have time now to detail other cases in which the court, other environmental cases in which the court has applied this Chevron framework, but I'm happy to talk about them in the Q&A if anyone's interested. And one notable example is the recent 2007 climate change case, Massachusetts versus EPA. I will say just briefly that I entirely agree with Deborah that Chevron is consistent with Hamdan, and that the explanation of the difference in outcome turns on the fact that what Stevens is advocating for is deference to reasonable decision-making and not utter abdication of the court's role as an important constitutional backstop when, in the court's view, the executive decision is not reasonable or even reasoned. So turning back to environmental law, let me explain just very briefly why I think that Stevens' view of a limited role for the judiciary has had a salutary effect in the environmental arena. In the wake of Chevron, environmental advocates have, of necessity, had to sell their cause to the public. They've had to explain why we need affirmative environmental protections in the courts of public opinion rather than the federal courts. That's a very frustrating route to have to take with an issue like climate change that is so hard to explain to the public. But it's my view that long-term success on an issue as complicated as that requires a framework of positive law. It would be impossible to build a national energy policy via the slow accretion of common law rules. I mean, imagine an energy policy that was based on levels of scrutiny, for example. The only way to get a sensible and comprehensive energy policy, of course, is to convince the public that that's necessary and then assist Congress in figuring out what the pieces of that puzzle should look like. We're in a particularly disheartening time with respect to that policy building effort right now. But we had a lot of successes in the 70s with respect to clean air and clean water, and we have a lasting, though somewhat flawed, legacy to show for that. And I just have to believe that we will eventually be successful with respect to climate change as well. And then when we are, Chevron and the reasoning behind it will serve to ensure that the agency that is charged with implementing the climate change law, once it's eventually passed, will get the appropriate deference to its expert judgments, and that its rulings, therefore, will withstand challenge from private sector critics.
Thanks, Amanda. Jamal?
Thank you. Thank you all for coming. I want to first echo something that Deborah said, which is one of the kind of silver linings of the retirement of Justice Stevens is getting to go to events like this and hear my co-clerks. I've learned so much from this panel, and I've learned from these kinds of events over the last several weeks, so I've really enjoyed that. I'm going to pick up on something Cliff talked about, which is Justice Stevens' role in what I'll call the right to privacy cases, although, as I'll explain and as Cliff suggested, that's not really quite the right label for these cases, and Justice Stevens has an important role to play in that. By right to privacy cases, I'm talking about the cases that basically start with Griswold versus Connecticut, the right to contraception, right to abortion, right to family decision-making, right to sexual intimacy with the partner of one's choice. And maybe one of the first things to say about the right to privacy and the right to privacy cases is that at first blush, Justice Stevens has actually very little to do with these cases. If you look at the significant cases in this area, you'll be hard-pressed to find a majority opinion written by Justice Stevens. He hasn't written the big cases in this area. That's not to say that he hasn't had a very significant role to play. Some of you might remember, maybe most of you would remember, during Chief Justice Roberts' confirmation hearing, he was criticized for referring to the right to privacy as the so-called right to privacy. He did this in a memo he wrote for William French Smith in the Justice Department in 1981, so 25 years before his confirmation hearing. But the main part of the criticism was that this was a kind of code for being opposed to substantive due process, for being opposed to abortion rights. How do we know this is a code? Well, that formulation, the so-called right to privacy, shows up in 1988 Department of Justice Guidelines on Constitutional Litigation, written basically by Ed Meese and his staff. It shows up in Justice Scalia's dissenting opinion in Lawrence versus Texas. It shows up in an introduction to a volume on the history of originalism written by Stephen Calabresi, the founder of a rival organization that will go unnamed. And so John Roberts, Antonin Scalia, Ed Meese, and Stephen Calabresi. This is the kind of four horsemen of the conservative apocalypse using this formulation, so-called right to privacy. But it has an older pedigree, right? Justice Stevens, as Cliff alluded to, actually himself uses that phrase. He actually says the so-called right to marital privacy in an opinion he wrote in 1975 as a member of the Seventh Circuit in a case called Fitzgerald versus Porter Memorial Hospital. Fitzgerald is a case in which a father was suing to get the right to access to the delivery room of a public hospital for the birth of his child. And he was claiming a substantive due process right to that access. And Justice Stevens writes an opinion for the majority as a 2-1 decision of the Seventh Circuit, saying that there is that at least the right to privacy doesn't cover that right. And in the course of doing that, he says, he calls it the so-called right of marital privacy. So is this another example like affirmative action, like perhaps the death penalty in which Justice Stevens has changed his views? I don't think so. He was actually using that so-called right to privacy label in that case as a way of suggesting that the label is too narrow for the importance of the rights that it's covering. This is not an example of him saying these rights don't exist. It's an example of him saying we need a better way of talking about these rights, a more reasonable way of talking about these rights. I love the discussion of Chevron because reasonable is when I think of Justice Stevens, that's the word I think of. He's all about what is reasonable rather than having sort of bright line rules. So in that decision in Fitzgerald, he says, it is somewhat unfortunate that claims of this kind tend to be classified as assertions of a right to privacy. He goes on to say, the character of the court's language in these cases brings to mind the origins of the American heritage of freedom, the abiding interest in individual liberty that makes certain state intrusions on the citizen's right to decide how he will live his own life intolerable. The rest of the story is somewhat well known. In Bowers versus Hardwick, which was Cliff's turn on the court, Justice Stevens refers back to his language in Fitzgerald in his dissenting opinion. He says, we call these privacy cases, but we really should be talking about liberty. In Justice Kennedy's majority opinion in Lawrence versus Texas, 17 years later, he refers back to Justice Stevens' opinion in Bowers and says this should have been controlling, and conspicuously, Justice Stevens' opinion in Lawrence does not refer to the right in privacy terms, although in popular discourse it's often talked about in that way. Lawrence Justice Kennedy's opinion does not call a right to privacy. He talks about liberty at great length. And in fact, if you look at the court's doctrine over the last 30 years, the court actually hasn't referred to the right to privacy in upholding or extending any right, actually since Carey versus Population Services International, which was a 1977 case extending contraceptive rights to minors. Since that case, no case in which the court has actually upheld what's called a liberty right now, has upheld a liberty right in the area of kind of sexual privacy, family decision-making, has the court relied on the right to privacy. And so that is he's actually ended up transforming the doctrine without actually writing a significant majority opinion. Very briefly, I want to talk about what I think are three advantages to thinking about privacy in the terms in which Justice Stevens, I think, has thought about it. One is substantive, one is methodological, and one is strategic. Substantively, referring to liberty rather than privacy enables the right to at least more comfortably fit a wider range of rights that Justice Stevens certainly thinks are very important. Conspicuously, I would include the right to not just abortion rights, which I think fit more comfortably in liberty than privacy, but also marital rights, which will obviously become important to the court over the next 5 to 10 years, fit much more comfortably in a liberty framework than a privacy framework. Methodologically, there's been this not-so-silent textualist movement over the last 25, 30 years on the court and outside the court. Liberty has the advantage of being in the Constitution. Privacy is not in the Constitution. And that is an effective rebuttal for those who would say, well, there is no right to privacy in the Constitution. I have my Constitution right here. I don't see privacy. Well, liberty appears several times in the Constitution. Now, of course, there are arguments about substantive due process and the extent of it and whether that's an oxymoron. We can have that debate, but I think once you're having the debate about whether liberty refers to substantive or procedural rights, then, to paraphrase George Bernard Shaw, you're kind of arguing about the price at that point, right? You're on a different ground than arguing whether privacy exists or not within the Constitution. Finally, strategically, liberty has the advantage, for whatever reasons, we won't put Justice Kennedy on the couch today, but has the advantage, for whatever reason, of appealing to Justice Kennedy's instincts in a lot of these cases, his sort of libertarian instincts, his instincts towards a certain kind of grandiosity. And I've said before, and I'll say again, I think one of Justice Stevens' biggest influences on Justice Kennedy is not making backroom deals, phone calls. This is not his temperament at all. He's not a strategic player in that sense. And I don't even think it's in terms of opinion assignment. I think that's been overstated. I think his biggest influence is really the power of his ideas. And I think that's really what we're celebrating today and what we've been celebrating over the last several weeks.
Well, that was such a fantastic education across decades about Justice Stevens' work. I'm going to ask a question or two, but prepare yours because we'll turn to your questions in just a second. I was struck by, and perhaps understood a little differently than Cliff did, the quote from Justice Scalia, whereas Cliff read it, called Justice Stevens as someone with brilliant and distinctive insights. I thought that might have been a little euphemistic for, idiosyncratic nut. And I want to ask a question based on what was in his early days, and we really didn't touch on this. There's a kind of sense that he's been consistent through all the years, and he may well have been. But the early image of Justice Stevens was if it was an 8-1 decision, he was likely to be the one. And if it was a 5-3-1 decision, he was the one with the weird theory. And that, he was not part of mainstream legal thinking. And that has completely flipped around. And he has really emerged as a leader. And I'm wondering what you guys think that might be attributed to. Did he change? Did the court change? Did the way of thinking about the law change? Why did someone who, 30 years ago was viewed as almost an oddity turn into a figure so central as we've been discussing?
I have an initial thought, and then somebody else can say something more profound that gets at the heart of the question. But my initial thought is that I think he believes strongly in writing and the importance of written opinions for the building of this, I think of the common law as a brick wall, the importance of each brick to the building of the wall. And so he writes whenever his view differs at all from the majorities, even if he's in the majority, or from the dissents, even if he's in the dissent. He dissents and thinks it's important to dissent, even in a case where he's on his own. If he disagrees, the easier thing to do, the easier thing for his clerks certainly would have been to say, it's already going to be 8-1, we might as well make it 9-0, right? But he doesn't do that, and he doesn't do that for a very principled reason, which is he thinks that the airing of all views is important to the way that the law evolves. And so I think that maybe what I'm explaining is the first half of the career. I think the 8-1 is not explained as well by his being an oddity as by his view that whatever his notion about a case, he has an obligation to his job to get it down on paper.
Just want to briefly follow up on that. I would echo exactly those comments. And first, I would say that I still think it's the case that if it's an 8-1, there's a pretty good chance Justice Stevens is the one. Justice Thomas gives him a run for his money sometimes, but I think he still thinks it's very important to air.
There are days when the court announces 4 opinions and Justice Stevens wrote separately in 3 of them. That happens not
Right. And I wanted to say a word about the way I think what Amanda just said connects with what Jim earlier said about democratic deliberation. And in the death penalty area, the need to bringing the views of different states, different jurisdictions, different juries. I think this is all related to his view that one of the ways in which the law evolves in a principled way, in a reasonable way, is to make sure that everyone's views are aired. And that part of that process is making sure he gets his own views on paper when he has a different, perhaps idiosyncratic, but as we've seen over time, those idiosyncratic views can become part of the fabric of the law. And I think this is all connected.
I could just add one thing. We forget that when Justice Stevens came onto the court, even though he has dispositions that we recognize as liberal or progressive, the progressive wing of the court was very different from him. And I think he, in many ways, had more trouble essentially kind of linking up with the thinking of a Justice Marshall, let's say, or a Justice Blackmun in his liberal phase than he did with somebody like an O'Connor or a Kennedy or people who tended to be in the middle. And I think in that way, the court did move towards him, not so much that it became so conservative that he just stayed where he was and became the liberal, but just that a more pragmatic approach to things, a desire to focus on institutional respect for different parts of the government and for facts and things like that are somewhat apolitical, did become what is very characteristic of the middle of the court. It's actually pretty characteristic of the left of the court right now. It's not so characteristic of the right of the court, but I think that in that way the court moved towards him, and he had less to dissent about because there was at least a kind of agreement on that part of it.
I just want to add one point. I agree with everything that has been said, but I also think there's an important point about writing on the court. And present company excluded for anybody who covers the court, but there is this tendency in covering the court to want it to be a simple storyline of the liberals on the court and the conservatives on the court, and it's a lot easier when people can write about a Scalia and a Brennan, and that's not Justice Stevens. I mean, to this day, the leader of the liberal bloc, he's not a leader of the bloc. I mean, even when I was clerking, he was still referred to as the maverick, That is still how he approaches every case. And the force, as has been mentioned by a number of people, of his intense commitment on each case to the facts and the laws, frequently leading to a distinctive view. Sometimes it leads to an 8-to-1 opinion. Sometimes, as Justice Scalia's quote indicates, and as any of us could tell stories about, it completely turns around the way the court looks at a case, and not only in terms of whether it's conservative or liberal, just completely turns the case on its side. So I think there is an important lesson about the way that the court is sometimes oversimplified.
All right, I'll say something. I was gonna resist, but I mean, I would also say it's easy to talk about, or easier to explain why he wrote separately so much and still writes separately, because that is so much part of who he is. I do think it's true that as the court moved, and it became, in lots of areas, really important to have some unity on different questions, even if it was only a 4-justice unity, not a 5-justice unity, or where there might be a possibility of getting a 5-justice unity if it could just be one opinion. My sense is that he recognized that he served an important institutional role in being able to do that sometimes, and that could be as important as writing separately, and that became more important than it was when there were so many different voices on the court, and voices like Brennan's and Marshall's that really were a different perspective that's kind of gone from the court now. So he needed to serve that role, and that's part of how he developed with the institution.
Well, let's turn to your questions. Go ahead. We have a microphone. Go ahead and address them to the panel as a whole if you want, or to someone in particular if you'd prefer. Yes, back there.
Actually, two completely different questions. One is if anyone could address what you think accounts for his decision in the Pacifica case, where he wrote the 5-4 decision upholding the restrictions on indecent broadcasts. But my other question is really for you as clerks. I understand that Justice Stevens was one of the few justices that did not rely on pool memos. And I'm wondering how that affected, if you think that might have accounted for sometimes his distinctive view of things and how that affected you in terms of your workload and how you related to other clerks.
On that second question, maybe someone could just explain the logistics of the cert pool.
Yeah, I'm happy to. So when I was clerking, and the ratio varies, but when I was clerking, 8 of the justices were in the cert pool, and Justice Stevens was the only one that's not. What's the cert pool? Every year, the Supreme Court gets 5,000-6,000 petitions for cases that it should review, or at least that was the statistic when I was there. How does the court decide which cases to pick? It has a couple of rules. They're pretty broad. But basically, for 8 of the justices, all of the petitions come to a central place, basically, and they're divided among the chambers. And then the one clerk, in whoever's chambers it is, whether it's a Thomas clerk or a Kennedy clerk or a Breyer clerk or whatever, will write a memo on the cert-worthiness of that case. Should we take the case or should we not? And little capital letters at the bottom. Chief Justice Rangos was hugely opposed. He had abbreviations you could use and abbreviations you could not use, but in any event, recommending grant or deny, or on rare occasions some other dispositions. And then there was the Stevens clerk memo, and all 5,000-6,000 petitions for review, spaced out over the course of the year, would come to our chambers. We would divide it up among what were then 3 clerks, although we had that year the visiting then retired Justice White's clerk, and divided up among the 4 of us. So every month, I guess, we'd have 40, I can't really remember, 40, 60, 80 petitions apiece to review. And instead of writing a memo on all of them, because a large number of them, and boy, was the learning curve steep. So once you'd seen one Sixth Amendment ineffective assistance of counsel claim, right, you started to get a feel after the first couple of months of which were meritorious or not just meritorious, but cert-worthy in particular, and which weren't. You'd only write the justice memos on cases that you thought he needed to be aware of, whether they were grants or denies. Certainly if you wanted to recommend a grant, you'd write a memo to the justice. But if you wanted to recommend deny or thought he should be aware of it or were struggling with it and wanted to talk it over with the justice, you'd exercise some judgment in writing memos about those. So in any given cert decision the court was facing, the term I was there, the justices had unless they read all the papers themselves, and on occasion they did, but mostly not, the cert pool memo and the Stevens clerk memo. So I'm happy to say a little bit more about what I think about that, or maybe I should, and then I'll shut up. Number one, I think it's utterly emblematic of Justice Stevens' independence and respect for the law and everything else. How did it affect my work? Well, without question, we spent more time deciding which, on cert pool, reading cert petitions than other clerks, without question. And the other clerks often said, oh my God, how can you do that? It's awful. Viewing that as sort of the worst part of the work of the court. But I have to say two things. One is, oh my God, this is the one shot at the Supreme Court. More than one 20-something-year-old clerk should read the petition, really. Secondly, it gave us, and this is self-serving to some extent, but I really remarked on this at the time and even in hindsight, a remarkable perspective on the view of what issues were out there in the U.S. federal judiciary and even the state courts of federal courts, percolating up. So the sensibility of where things are really becoming sort of repeated chronic issues, where issues are really becoming hot, and what makes a good case, a case appropriate for court review and what doesn't. I guess I thought, boy, you learn by experience, and as a clerk, you have so little before you get to the court. It seemed to me an enormously valuable exercise.
Does anyone want to talk about the Pacifica case? And maybe I'd add in the flag burning case, where those of us with some First Amendment sympathies that may lean in the other direction were surprised by Justice Stevens' thinking.
Well, I'll take a stab at it. And, one of the things that I think it reflects is that Justice Stevens, as we've said many times, really focuses intensely on the case in front of him. His constitutional law professor in law school, Nathan Nathanson, if I remember correctly, who was really a hero and mentor to him, warned, and who had been a Brandeis clerk, warned the students against glittering generalities, against these sort of broad propositions of law to apply in all situations. And you will find that Justice Stevens makes very careful distinctions, whether it's an affirmative action, where, as was mentioned, if it seems to have a reasonable basis, such as for the purpose of diversity in higher education or in elementary school education, completely unrelated to remedial purposes, he'll embrace it. If it looks like pork, like in a highway program, he will find it impermissible. And similarly, in the First Amendment, he doesn't go for the glittering generality that because you invoke the First Amendment, in his perspective, therefore you suspend your reasoning, you suspend looking at the individual case and just sort of throw your hands up and defer. And so, for example, in the Pacifica case, his view was that when you're talking about the George Carlin dirty words, and when you're talking about a situation on the radio, when it can come unannounced, when there's a kid in the car, and all of those factors, that it is reasonable and appropriate. Now, later, when it wasn't reasoned in the most recent FCC indecency case, he was against what the FCC had done there. And similarly, it's the same thing with the flag, which many people disagree with him on, and he always knows that just about all of his clerks disagree with him on. But I think there he thought that, well, just that when you're just invoking the First Amendment, you don't suspend your reason, and that in his view, there is something unique about the flag as a symbol, and which justifies the prohibition. So what I think it really goes to is that in any context of the law, he will make reasoned determinations. I mean, in the First Amendment, he used to say, and he said this in opinions, and I think it's reflective of both Pacifica and the flag case. He says people say you can't make distinctions about content, and he says, well, of course, you can ban talking about baseball during math class. That's a distinction based on content. And so just those glittering generalities that Nathanson warned him against, he will always be very careful not to apply these, just sweeping blanket rules that, in his view, relieve you of thinking about the case.
Other questions? Yes.
What will Justice Stevens do after he retires?
Did you hear the question? The question was, what will Justice Stevens do after he retires?
I asked him that at the reunion last week or a couple of weeks ago, and he said, it's the end of the term, and of course, everybody's end of the term, it's a nightmare. It's unbelievably busy, right? You're struggling to get out the last opinions of the court. They're usually the most important opinions because the court's been struggling with them. And I really haven't thought about it. I really haven't had time to think about it. And I completely, believe that. If I had to guess, my guess is he'll keep in office. He'll remain a reasonably active retired justice as long as he can, and wouldn't rule out, sitting by designation in cases in the circuit courts or whatever else. I mean, he just, at least in my impression, his lawyerly mind is completely as sharp and active as ever, and it's hard for me to imagine, although he certainly deserves it, that he'll just embrace golf and tennis full time.
Other predictions?
And Sudoku.
Yes.
It seems that Kagan might replace Justice Stevens. Oh, thanks. So it seems likely that Kagan will replace Justice Stevens. If she does, is there a particular element of Stevens' legacy that you would like her to see carry forward?
All of it. But I mean, in all seriousness, it's in the beginning in the 20th century, it's a very distinguished seat. For most of the last 100 years, it's either been held by Stevens, Douglas, or Brandeis. So it's a great legacy as she enters the seat. She could have no better mentor. The one thing I will say on that cert pool question, which sounds like a very small thing, I strongly hope she doesn't join the cert pool. And Justice Alito had decided not to, and Justice Sotomayor, I think, said she was going to try it for a year and then evaluate it. I'll go a little bit further. I think the cert pool is a bad thing. I think Justice Stevens is exactly right, and I think part of it is his concern about groupthink, and that when somebody's writing for 8 justices or 7 or 6, they're going to write very conservatively because everybody's going to throw things at them. So that's one thing. I certainly hope that she doesn't join the cert pool.
Yes.
I was thinking, isn't that one of the reasons possibly why there's fewer searches granted?
So the question is one of the reasons the Supreme Court docket, as you all know, has shrunk radically from about 20 years ago, by about half to maybe only 70 merits decisions a year. Some people speculate the rise of the cert pool has something to do with that. Is that right?
It's true that some people speculate about it, and there's actually been quite a lot written about it and studies done to evaluate whether it's true or not true. I think there's not an answer to the question. There are reasonable arguments on both sides. It's definitely true that the memos that come out of the cert pool are much less likely to recommend a grant. And I would think that if there were no justice not in the cert pool, that could have a shrinking effect. But in fact, lots of cases, at least this was my experience clerking in '96, there were not a lot of cases that we saw in the Stevens chambers that we thought, oh, that should have cert granted, where the cert pool didn't recommend a grant. So on the one hand, I think the way that the cases are talked about is very different, and more conservative. You're less likely to get as many into the conference for discussion. I don't know. I don't think that can be the only thing, or even the primary thing that explains the small number of cases. Smaller.
I don't think the cert pool is the reason for the shrinking docket. I mean, the year that I clerked in the court was hearing about 150 cases a year then. There were 6 justices in the cert pool, in addition to Stevens, Brennan, and Marshall were not. But I don't think that's the factor. My own personal unscientific view is that it's the change in personnel on the court, because Chief Justice Berger and Justice White especially, and to a lesser degree Justice Powell, were 3 of the most likely votes for grants. But when I was clerking, especially Chief Justice Berger and Justice White, if there was any any remote hint of a split in the circuits, he was really pushing for the court to take it. And you may recall he was pushing for an intermediate court of appeals because he thought the Supreme Court couldn't handle the workload because of all the splits. And Chief Justice Berger was pushing a lot of cases, particularly if a government at any level was a petitioner. And so, anyways, that's my own view, is the change in personnel on the court.
Every justice has clerks. All of them now, I think, have 4 each. Every clerk, at some point or another, ends up writing a cert memo. So, I guess if you're in one of the chambers in the cert pool, you end up with, I don't know, 8 or 10 memos a year. I don't remember. Do you know how many?
1/32 of the ones that come through.
Yeah.
And there were about 10,000 by the time we were on the
they're
court.
equally distributed, yeah.
Again, demonstrating that lawyers and math skills don't necessarily overlap.
That's true.
Yes.
Ken Joseph with CQ Press. I'm curious whether any of you have heard Justice Stevens express regret about any of his own decisions or positions.
I guess I would say that in the capital cases that came before the court in 1976, there were 5 cases. There were 2 that were clearly guided discretion, Florida and Georgia, very much like the model penal code. And there were 2 that were mandatory death sentences. And then there was Texas. And Texas was kind of in between. And the court struggled very mightily with whether to put it into which of the 2 categories. And my impression over the years was that that was something that Justice Stevens and the other justices struggled with a lot, and that had he had it to do over again, he might have put Texas into the other category. And it really plagued the court. A lot of problems out of Texas. The court spent a lot of time on them, really didn't get them sorted out until the late 1990s, so, for whatever that's worth.
Justice Scalia has also talked about in kind of the same terms. But then you also emphasize how Justice Stevens has attempted to maintain some stability in the law and respected the rule of law in a way that he tried to decide things narrowly. And then sometimes those 2 kind of principles seem at tension. And I was wondering if you could kind of speak to how he viewed dissenting opinions that maybe weren't even his own, and how he thought about them as legitimate sources of legal reasoning, and how maybe he thought about inserting them into opinions if he did, and maybe if that differed from other members of the court.
Well, this came up before a little bit in Adam's question about his view about dissents, but Justice Stevens, one of the things that people have drawn this comparison with Kagan, that because she's sort of political, she was very good at bringing the Harvard Law faculty together, which was a monumental political success and challenge. And Justice Stevens would never think of himself as what that suggests, that is somebody who wanders from chamber to chamber, schmoozes the other justices, and then says, maybe we can find a deal here or something like that. When I was clerking with him, my co-clerk and I took him out to lunch and said, Justice Rehnquist, then Justice Rehnquist, has begun this process of having lunch with Stewart and Powell frequently during the week and sort of bringing them around, and you could sort of see the changes in some of their votes, particularly Stewart in a way. And so we were talking to him about whether he thought that was something that maybe ought to be done on the other side. Justice Brennan was still on the court, was doing that, but was ill, and his wife was ill, and there were issues about his ability to continue doing that. But what Justice Stevens told us and said, and he actually referred to the Brandeis and Holmes, the great dissents of theirs that became the law years later, was that everything had to be in an argument, in a formal argument that was made in the appropriate manner, either in an opinion or in the conference of the justices. And I think that he really took very seriously the view that if he had an opinion about the way the law should go, even if it was different from others, the only way that he could actually advance that was to state it. And so it was very important that he do so in a concurring or dissenting view, even if it was a lone one. And I think he respected others who did the same, and he'd sometimes write so he could write, to oppose some of theirs. And now there are frequent decisions that are written just to, criticize what Justice Stevens did. Justice Scalia and Thomas like to do that sort of thing, Alito frequently. And I think he values that because he thinks that's actually how the law develops. And I wouldn't be surprised, actually, if that's something that changes on the court, where you get less of that sort of thing, maybe to the detriment of the court.
I was just going to say, it's an interesting question. And I was trying to think if during the time I was there, I felt that there's intention. And in fact, so I was remembering in particular two, I guess one was a dissent, one was an 8-1, where we were the one. And we were so right. And the other was, I guess, a concurrence in which, he was with the majority, but a number of people were writing. And in neither case, did those feel like dissents that were in any way designed to push the law, or that felt in any way like pushing back against stare decisis or precedent. So you had this, people have written about the Rehnquist model, and not just Rehnquist, but he's a good model of sort of writing dissents in an attempt, and ultimately in many fields, a successful attempt to push the law in a place that it wasn't currently, right? Federalism questions, big, But Stevens, so the one in which we were 8-1 was essentially a gigantic federal contracts case. Anybody who knows me knows that this is not necessarily my main, area of interest, but it was essentially, Mobil Oil versus the United States, and I can't even remember why it came to the court, but it was basically a contract case, and it was a highly technical, contract case, and the court came into it with this very received view that everybody was going to vote one way, and we got the case and we looked at it, and the more we looked at it and looked at the contract treatises and looked at the common law and looked at the whatever, the more it became crystal clear that the nature of the law had been the opposite of what the majority was concluding. So I would view that as entirely consistent with the general Stevens view of, trying to doing his best in a technical way to uphold the law. And the other was an abortion case. The term I was there, we had Stenberg versus Carhart, which was a so-called partial birth abortion case that was before the court now has concluded, statutes banning partial birth abortion are okay. At the time, the court concluded 5-4 that without an exception for the life and health of the mother, those statutes were unconstitutional. And O'Connor wrote, I think, the controlling opinion for the court in that case. But Stevens felt compelled to write separately because, in his view, it was the distinction the law was trying to draw was a distinction between one method of abortion and another method of abortion, that if you look at closely enough and have the technical descriptions, and we had thousands of pages of amicus briefs in great detail describing exactly what this procedure was. And the big argument against partial birth abortion was that it is especially gruesome kind of procedure. But if you looked at the technical descriptions, all abortion procedures could be described as a pretty gruesome set of events. And for the law to distinguish on that basis was simply, in the justice's view, irrational. In other words, really, this is what we're talking about. And so you didn't even have to get to the liberty, heightened scrutiny, whatever. This was simply an irrational basis for distinguishing. And in that concurrence, he also made the dissent, and made the point, and I forget the numbers, but of the this is why I married an astrophysicist and I'm not one. Of the 22 justices who had ever been called to decide an abortion case on the court by that time, 20 of them had recognized some basic fundamental right there. And it was time to stop trying to revisit this basic question particularly on the basis of distinctions that he saw, and I think rightly saw, as irrational.
Well, I'm sure a lot of you would agree with me that there would be nothing more fun than to sit here all afternoon and pepper these guys with questions. It's so interesting, but I know you also have work to get back to, so I think we better say thank you to our panelists.